everyone. How are you doing? Hello. Hope you're good. Hope you're fine. You're welcome to Lawyers Info Hub. It's a pleasure to create content on this channel. So today we're looking at a civil litigation series, matters that need not be what pleaded. Now, civil litigation or civil procedure is very important. This is a core of litigation as much as criminal litigation is also very important. But as a lawyer, understand how to go about, your pleadings, issues of evidence, what to plead, what not to plead, how to draft your pleadings, you know, as not just a normal lawyer, as a smart, intelligent lawyer. You know, sometimes people have lost cases because of the way they have, you know, they did their pleadings. They didn't do it so well. What are you supposed to plead? What need not be pleaded? What are the things that you must plead? How do you plead? And all of those things are very important. So today we're looking at what are those matters that you don't even need to plead, because you need to know which one must I plead, which one that are those ones that I need not plead, because um, by some means or by some way, the court is aware of it somehow. Yes. So we're going to look at it. Let me not jump the gun. We're going to look at them. So there are certain facts, the existence of which what presumed in favor of a party by virtue of the provisions of the rules, principles of the law of what evidence. So a party need not plead them, uh, when you're doing your pleadings. This is Lawyers Info Hub. It's a pleasure to always create content here. If you're here to subscribe, please do hit the subscribe button, share the video, because someone might learn something from this class. For my returning subscribers, thank you. Thank you. Drop your questions, drop your comments in the comment section. We will receive attention. It will receive attention. If you need response, it will be responded to. So we're going to look at the three matters that need not be pleaded. We're going to discuss these three with respect to this class. The first one is the performance or occurrence of what? A condition precedent. What is a condition precedent? A condition precedent is a state of affairs or something that needs to be done before a party takes steps. If, for example, I enter into an agreement with someone, and in that agreement, we note that before I can sue or before I court where there is a default, I must notify the other party within 1 month or give the party a 1 month notice. It's a condition precedent. If at the end of the day there's an issue and I fail to notify that party, giving that party a 1 month notice, and I rush to court, they will come and say, my lord, there is a condition precedent before an action can be instituted, which is notification, to us for giving us a 1 month notice, and it was not done. So it can be raised as a penal objection, and the court will look at it. Yes, both parties agree that this thing must be done before this step is taken. If, for example, parties have agreed that we must submit to arbitration if there's need for us, if there are issues or the default, or there's a problem, we must submit to arbitration before going to court. It's a condition precedent. So different circumstances, different issues. So where there is need to pay performance or occurrence of a condition precedent, these are matters that need not be pleaded. Yes. So once there is a cause of action, the person in whom it is vested may sue. Yes, but just like I've explained to you, where there's an agreement and something has to be done before some other thing happens, and that thing is not done, it has become a condition precedent. You need not plead it. Yes, you need not plead it. Like in Lagos State, Order 17 Rule 6. Order 17 Rule 6 is very, very, very key. Is very, very key. Also, if it's in Enugu, look at Order 15 Rule 6 of the High Court Rules. Very, 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 very what? Important. So if the defendant, for that, in Enugu, the rules provide that the defendant's failure to plead the non-performance of the condition precedent due performance was will be presumed. So we have to be very careful. So when you have clients there are issues. These are part of the things you need to ask them. Was there an agreement, for example? When you look at the agreement, is there a condition precedent? So either you are for the plaintiff, either you are for the defendant. These are things you look out for. Was there a condition precedent? Did your client or the other party comply with the condition precedent? Then no, then it can be what presumed. It need not be pleaded. Once that once the document or the agreement is being presented to the court, and then you can rely on it, to raise your objection. We have agreed that this must happen, and it didn't happen. You jumped the gun. So, as much as the fulfillment of that obligation imposed on the aggrieved by the agreement, for example, is not part of the course of action, but what is an essential prerequisite for institutional action. So, as much as that pre-action or that condition precedent, is not what it's not like the course of action, but it's what is a prerequisite. If, for example, I'm supposed to notify you 1 month before going to court, that notifying you does not mean I'm not aggrieved. That notifying you does not mean that what was the other party supposed to do, they should not rely on you and not to do it. No, what it just means that as much as you are aggrieved, you want to go to court, yes, but by our agreement, you must notify me. This is just an example. Give me 1 month notice before going to court. So that circumstance has become a condition precedent. So where there is a performance or occurrence of a condition precedent, is one of those matters you need not plead. You need not plead it. So you can utilize it in your matter. So another thing I want to discuss is that another one is presumption of law. Yeah, presumption of law. What is a presumption of law? A presumption of law is a conclusion which the law prescribes or stipulates that should be drawn from a given set of what facts until the contrary is proved. There is, you see some people in the talk, they say that the presumption of law. Yes, because it's a conclusion which the law has already prescribed, which the law stipulates that should be drawn, an inference that should be drawn from a given set of facts unto what the contrary is what proved. For example, if two people, are parties to a covenant or parties to a deed of assignment, or just for example, it's assumed that both of them are of age. For example, if two people are married, they assume that both are consenting adults. Both are adults of that are adults, they are of age. They are what of age. They assume that this marriage are between people that are of age. So it's a presumption of law that see, marriage should be for two, not just for children. This person. So it's a presumption of law. So unless there's a contrary, something, so there's something else to show to the contrary that this person, maybe one of them is a child. I'm just using this as an example. So a presumption of law is just a conclusion which the law has already preserved. Is this happen? We presume this and this. If someone goes missing for so number of years, we presume this person is dead. So these are what presumptions. If, for example, someone acts in a public capacity, if someone acts in a public capacity, there's a presumption that the person is authorized to act. If the person presides over a tribunal, there's a presumption that the person is what authorized, or the person has that capacity or has been appointed to preside. So a presumption of law, therefore, it saves a party who can invoke it from proving certain facts in the first circumstances and puts the onus on the other side. So for a person who wants to rely on the presumption of law, what it does is that it saves that party who, from proving certain points. The law has already presumed that if this didn't happen, this is what we should presume. So it is not left for the other party. The onus now rests on the other party to prove to the contrary that no, this and this happens. We cannot rely on the presumption of law. So when the issues of presumption of law, these are part of matters that need not be pleaded. Yes. You can also look at Section 129 of the Evidence Act, very important issue of when a deed is 20 years and above. A deed that is 20 years and above, there's a presumption of law, and the probative value that the court always attached to dates that are over 20 years. Now, a party whose favor or presumption of the law operates is therefore not required to plead the fact thus presumed in his favor. So, when there's a presumption of law, to the party who it inures to, the person need not go about proving, pleading. No, the only now rests on the other party to say, no, this presumption of law cannot stand for this party or in this person's favor because of this and this. So a party does not have to prove and plead a fact to which the burden lies on the other side. So if the burden of proof lies on the other person's part and there's a presumption of law to that fact, you need not go about pleading it. Yes. Very, very, very what? Important. Is in the rules for every jurisdiction in practice. Look at the rules. It's always a presumption of law. It's always in the rules. Very, very important. So a party may not allege any fact, a matter of fact, which the law presumes in his favor. So there are presumptions of law in the favor of a party. So that party need not go about pleading it, trying to prove it, but no, the onus of proof lies on the other party to prove to the contrary. So we've looked at performance or occurrence of a condition precedent. These are matters you need not plead. We now looked at presumption of law. So presumption of law is one of those instances you need not plead. It's like it is as it is presumed. It is there. For the other party who feels it should not be, should go ahead and prove to the contrary. So we also look at the third one is facts that are judicially noticed. Sometimes you see that the court would have taken judicial notice of something. When a court takes judicial notice of something, it's very, very, very important for you to understand what that means. So what is judicial notice? Judicial notice what is acceptance by a court the truth of a fact without ground that such fact is within the court's knowledge. So when you say the court has taken judicial notice of this fact, or when the court says, I have taken judicial notice, I have taken judicial notice, is very important. I've taken judicial notice of this. So judicial notice is acceptance fact without what proof on the ground that the fact is within the court's knowledge. So when a fact is what judicially noticeable, a judge or a magistrate accepts its existence as established without what evidence to that effect by any of the parties to the work proceedings. So even in the Evidence Act, it says no fact of which the court takes judicial notice need to be proved. You don't need to prove a fact that the court have taken judicial notice of. So it's fact that are judicially noticeable are one of those matters that need not be pleaded. So we've looked at issues of condition precedent, we looked at presumption of law, and we have looked at facts that are judicially noticed. Very important. Very important. So there are a lot of matters which the court have taken judicial notice of, and they are listed in the Evidence Act. So look at the Evidence Act and look at for those matters which the court have taken judicial notice of. So we discussed these three instances, very important. As a lawyer who understands civil litigation, civil procedure, this is very important. I need to know facts or matters which that need to be pleaded and proved, and the ones that need not be. So we have discussed these three that you don't need to. Issues of condition precedent, issues of presumption of law, facts that the court have taken judicial notice of. You don't go about pleading or proving it. Yeah, so it's been a wonderful class today. We're also going to look at that facts that should be specifically pleaded in our next video. Do take care. Please check the channel. We have over 200 contents. We have several contents that be of help, that will be beneficial to you. And we want you to take the most use of it. Listen, learn something. Knowledge is very important. Nobody is above knowledge. Even in everything someone I say, you might just pick out something very crucial for you. You don't need to even, everything might not be beneficial to you, but one thing can be very beneficial to you. Yes, just one thing can be very beneficial to you. Do take care of yourself and keep improving yourself. Knowledge is very important. Very important. Very, 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 very important. Yes. So take care of yourself and drop your comments if you have any. We are here to offer mentorship programs. We want to see you succeed. Law students, young lawyers finding the practice difficult, can give you advice, help you in any little way we can. We want to support the legal, and we're already supporting the legal law students when lawyers are being equipped, when their knowledge base is being improved, is increasing, you have a better results. Do take care of yourself and bye.